Hi, I'm attorney Bill Bronchick, and I'd like to explain to you how a wrap or wraparound works in the state of Colorado. A lot of attorneys are not educated in this field of law, and a lot of real estate brokers will tell you it can't be done when in fact we have closed over 600 wraparound transactions over the last 15 years in my office. Now, a wrap or wraparound is when you sell a property that has an existing underlying loan. There's a couple of ways to accomplish this. One is to deed the property from seller to buyer, and the seller takes back a note and what's called an all-inclusive trust deed, or AITD. In this fashion, the buyer makes payments to the seller on a note, and the seller makes payments on the underlying note, pocketing the spread if there is any difference in between. If there's no difference in between, it's referred to as a mirror wrap. If there is a spread in equity in payment, it's called an equity wrap. Another way to accomplish this is a very pro-seller version, which is called an installment land contract or contract for deed. In this scenario, title stays in the seller's name, or the seller executes title and it is held in escrow with a title company or attorney. Buyer makes payments on the wrap in the same fashion, except the buyer does not get the deed until the balance is paid off through the buyer selling, refinancing, or otherwise paying off the debt owed to the seller. If the buyer does not make the payments and does default, theoretically at least, the seller can evict instead of foreclosing, whereas with an all-inclusive trust deed, the seller always must foreclose a defaulting buyer. I say theoretically because Colorado doesn't have any specific prescribed process like other states do. For example, in the state of Illinois, when a buyer defaults on a land contract, there's a very specific procedure for getting the buyer out, which is a little harder than an eviction but not quite as cumbersome as a foreclosure. In Colorado, the seller goes into county court through an eviction, and if the buyer doesn't show up, which is mostly the case, then the seller proceeds with an eviction and the deal is over. If the buyer does show up in county court, then the case is transferred from county to district court, in which the argument is then laid out by the buyer, and in most cases the buyer does lose the argument unless there's a substantial amount of equity through appreciation, down payments, or substantial improvements to the property. The bottom line is the equitable argument that the buyer makes in tying up the case should only delay you a couple of months, not several years like some attorneys have claimed. In fact, most of the time the buyer does not show up because if the buyer can't afford an attorney, can't afford to pay, they can't afford an attorney. So most of the time the case is won in county court, and if it's transferred to district court, most of the time the seller wins anyway. The smartest thing, however, to do is if a buyer defaults, avoid court process altogether and offer cash for keys. That is, some cash to the buyer, give them some of their money back, get them to sign a release, and give you the keys back to the property. If you'd like a form or addendum to a Colorado real estate contract that spells out either a contract for deed, installment land contract, or an AITD wraparound, an all-inclusive trust deed, please email me at william@bronchicklaw.com and I will email you the appropriate addendum for use in a transaction. We also close these transactions in my office. If you have any questions, give us a call at 303-398-7032.